Good evening, everyone. Welcome to our program, in which we're going to be talking about the Vanishing trial. To lead us off, I want to introduce Molly Gill from FAM, the organization that's primarily responsible for this film. Molly? You have to unmute.
Thanks for having me here tonight. I'm so excited that so many people have signed up to see this new documentary film from FAM. FAM is a nonpartisan organization in Washington, D.C. We are almost 30 years old, and one of the things that we do best in our work for sentencing and prison reform around the nation is telling stories of people. And over the last 30 years, we have heard so many stories of what is known as the trial penalty. So many stories of people exercising their constitutional right to go to a trial, to have a jury of their peers decide the case, and then being faced with an exponentially longer sentence for the very simple reason that they refused to plead guilty for whatever reason. Perhaps they believed they were innocent. Perhaps they simply wanted to test the facts of their case in an open courtroom like our founding fathers gave us the right to do. And they find that they lose more and more years and even decades of their lives. And to us, these are always tragic stories, and we wanted to show these stories to throw some light onto this issue, because I think most Americans watch TV and Law and Order, and they think, oh, everyone goes to trial, and you have this dramatic courtroom battle, and maybe justice prevails in the end, and maybe it doesn't. And the reality now is that television is one of the only places you can watch a criminal trial these days, because 98% of cases in most jurisdictions are ending in guilty pleas, and the trial penalty is one of the reasons for that. So I'm so pleased to be here with Norm from NYSACDL, who has done just a groundbreaking report on this issue and brought this to light. And I wanted to say a note too before I introduce our panelists about the stories that you saw in the film. We are well aware at FAM, and I think the whole country is aware in this moment of how serious and significant the racial disparities are in our criminal justice system. And we're seeing lots of responses right now to try to address that, and we're supportive of those efforts. In the story, in the film, we really wanted to show lots of different kinds of stories and people that are being impacted by the trial penalty, knowing full well that communities of color are disproportionately impacted in negative ways by our criminal justice system. But we wanted to show that this is a problem that is impacting all kinds of people from all walks of life. And so you see in our movie, we have a story of a white collar offense, we have a gun offense, we have several drug offenses, men, women, white, Black, people all across this country of all different kinds of backgrounds in all different kinds of communities are experiencing the trial penalty. So it's a very serious and significant problem, and we hope this film will begin to shed light on it so that we can all work together to fix it. So thank you so much for watching the film, and I'm going to jump into introducing our very qualified panelists who are with us tonight. First, we have Robert Rose III. He's a New York City advocate for criminal justice reform and has a personal experience with the trial penalty in New York that he'll share. Jared Trujillo is one of our panelists with us tonight. He's a New York City public defender with the Legal Aid Society, and he's the president of the Association of Legal Aid Attorneys. Susan Walsh is with us this evening and is a partner at Vladeck, Raskin, and Clark with over 20 years in trial and appellate experience. And Susan chairs the New York State Association of Criminal Defense Lawyers Trial Penalty Task Force. And of course, we have Khalil Cumberbatch. He's the chief strategist for New Yorkers United for Justice, who is also a host of this screening tonight. That NYUJ is a coalition of broad and diverse organizations, and their goal is to pass criminal justice reform legislation in New York State. So with that, I'm going to turn it over to Norm so he can jump in and we can hear from these wonderful panelists we have tonight.
Thanks very much, Molly. I appreciate that, and I appreciate all of FAM's work on this. So I'm Norman Reamer. I'm here actually in my capacity as the chair of the board of New Yorkers United for Justice. which, as Molly just mentioned, Khalil is our chief strategist, and we've been working for the last 2 years to advocate for common sense reforms to transform the criminal justice system. I'm also sort of here as the executive director of NYSACDL, which has been working on the trial penalty problem for a number of years, and is one of our signature objectives is to do something about that. So I want to welcome all of you who are watching from around the country. Say good evening to those of you in the East, good afternoon to those of you who are in the West. And I hope you all had a chance to view the Vanishing trial. It will be released more generally in the next few weeks, but we hope you had a chance to view it during these past few days. The film is intended to focus attention on what we think is one of the most insidious and pervasive defects in the American criminal legal system at this time, and that is the trial penalty. That phrase refers to a systematic way in which accused persons, presumptively innocent people, are induced to waive valuable rights to avoid the hammer of a trial penalty. We think it is a key contributor to mass criminalization and mass incarceration. It provides the levers that insulates government overreach and police misconduct, effectively institutionalizing racial and ethnic bias, which so totally infects the criminal legal system in this country. The fact is, as Molly said, 98% of cases are not tried. Trials are becoming extinct. They are, as the title of the film suggests, vanishing. And I will say not only that we have established on the federal level, it's over 97% of cases are resolved without a trial. There are actually some places in this country where no criminal cases go to trial at all. But what's even worse is it's not just trial rights that are given up, it's many other fundamental constitutional rights as well. All because we've created a system in which the threat of a geometrically increased penalty is used at every stage of a criminal proceeding to coerce accused persons into surrendering fundamental rights. It's actually ironic that to put a human face on the dimension of this problem, we've profiled 4 individuals who actually went to trial. It's ironic because the real problem, of course, it's a horrendous problem for those people who get hammered with the trial penalty, but the real problem is that so few people actually can go to trial because of the trial penalty. Of the 4 people that we've profiled, they are all people who did not yield to that pressure and coercion, and 3 of them have paid a tremendous and cruel price. Eric Wyant was offered 3 years, and because of a mandatory minimum after he was convicted following trial, was sentenced to 20 years. Chris Young was offered between 12 and 14 years because they enhanced his sentence with 2 minor prior convictions for possession of drugs or for drug-related crimes, very small amounts. Because he went to trial, they enhanced his sentence, and he was given a life sentence. Sandra Avery, her more culpable husband, was sentenced to 17 years. She went to trial. She was given life. Fortunately, she received a clemency from the Obama administration, so she's home. Eric and Chris are still in prison. And Kevin Ring, although he avoided the worst of it, it shows you the enormous, intense pressure that's brought to bear. And the only reason he avoided the worst of it is because a judge had a measure of discretion, which is something we're going to talk about as potential solutions. Before I turn to the panel, I note that the film was in some measures inspired by the report that Molly referred to that NYSACDL produced. It's a report called The Sixth Amendment Right to Trial on the Verge of Extinction and How to Solve It. Jessica, if you could put that one slide up. And in addition to that report, which we're going to give you a link so that anyone can go and see it, there is a special double issue of the Federal Sentencing Reporter that was published with about 15 or 20 authors, all writing on the trial penalty. And I strongly urge people to take a look at it. These authors represent the left, the right, and the middle of the political spectrum in this country. They represent people from the academic world, practitioners, affected individuals. It is the one hopeful thing that I want to launch this discussion with, is that there is so much consensus coming around this issue from all different perspectives, that the leverage that we have given to force these this massive surrender of rights has to be rolled back. So with that, I want to thank our panelists. They've already been introduced, and I want to get right in to the discussion. And I want to start with you, Khalil. From your perspective, how common is the trial penalty in New York State?
Thanks, Norm, and thank you, Molly and FAM and NACDL for the amazing work that you've done in being able to tell the unfortunate story of the four individuals that are highlighted in the Vanishing trial. Unfortunately, Norm, we see as formerly incarcerated people, as advocates who are working to dramatically change the criminal justice or criminal legal system here in New York State, we see all too often people taking pleas because they don't want to be overly punished, simply because, as you mentioned, they're executing their constitutional right. As you mentioned, there are some places there's some states in this country where there are unfortunately an extremely high number of cases getting resolved through plea, but there are some local municipalities where that is all too often the lay of the land, where for you to be able to execute your right to go to trial not only means the potential of you getting a higher sentence, but also means that you could potentially languish in the system much longer. Most of the systems that we're talking about, there is the ability, depending on charge, to go to trial within a year or two. But there are some municipalities across this country and in the state of New York where unfortunately you could languish for 5, 6, 7 years in a pretrial phase. And so the combination of that, the combination of the threat of being punished more simply because you want to go to trial, simply because you want to face the evidence that is against you, and the fact that you could languish in a jail system that is all too often not healthy for many different reasons. Many people are taking plea deals, unfortunately, because of those combined circumstances.
Now, you've had your own experience with this, and if you don't mind, I would like you to share with everyone the experience that you had and how the trial penalty came into play, and we talk a little bit more in detail about how the fact that you didn't have to waive certain rights actually worked to your benefit.
Yeah, sure. I served 6.5 years in the New York State prison system. I took a plea deal because of the factors that we just laid out. One, I didn't want to go to trial and have to potentially face a higher sentence simply because I executed my constitutional right. The judge that I had in my, the original judge that I had in my case was one who had a reputation for being overly punitive, even in plea arrangements, let alone in trial penalty. And so I definitely wanted to avoid that. I took a plea and ended up serving 4 years of that original sentence. My original plea was the initial plea that I was offered was 15 years. Eventually, we were able to get it down to 11, but that was as someone who had no prior convictions in the criminal justice system. And yet and still I was given 11 years on my first offense. Fast forward 4 years, I was able to have my conviction overturned because I was granted entry into the highest court in New York State. But that was only because I did not have the ability to appeal my conviction taken away. And as ironic as that sounds, being that I just criticized my first sentencing judge, the reality is that for whatever reason, through the plea proceedings, that right wasn't taken away from me. And because of that right, I was able to appeal my conviction. And although I pleaded guilty, there was a procedural matter that was highlighted that actually overturned a lot of cases in New York State where individual was not properly informed of the full breadth of the sentence that they were taking, meaning I was sentenced to 11 years in prison, but I was also sentenced to 5 years on post-release supervision. And so I was not taking an 11-year plea deal. I was taking a 16-year plea deal. And that wasn't effectively explained to me at plea proceedings. And so my conviction was overturned. But again, it's only because I had the ability to maintain the right to appeal my conviction, although that conviction came through a plea deal.
Right, and we'll talk a little bit more about this. It's very common in most places around the country to require, as part of a plea agreement, that an individual waive their appellate rights. But what's interesting also about your case, Khalil, when you did get sent back, as you know, anyone who knows your biography knows, you had done amazing things during the 4 years that between the original sentence and the resentencing. And why don't you tell everybody what happened when you went back for this resentencing? What did the DA ask for, and what did you end up getting?
Yeah, sure. So just like most of the cases that were benefiting from this procedural matter that led to overturned convictions, many people, when they went back down to court, unfortunately, the district attorneys were just essentially offering you the same deal, just with whatever the post-release was added on. And so I was similarly offered the same thing. When I went down to court, my first offer was 11 years with a 5 years post-release supervision. But as you mentioned, Norm, I was on the beneficial receiving end of being at a facility, Greenhaven Correctional Facility here in New York State, that had a tremendous amount of programs that were designed and facilitated and implemented by men who were incarcerated for men who were incarcerated. And I benefited tremendously from those programs. And also within that 4 years, I was also able to have access to a year of collegiate level work. Now, I will say, and I am cautiously highlighting that because although those experiences completely transformed who I was as an individual, the reality is that I could have been given access to those same opportunities outside of prison. I could have been given an opportunity to go to college while my case was in a pretrial phase. And so I don't want to make it seem as if prison saved my life, but the reality is that had I not had access to these programs, similar programs exist outside of prison, I wouldn't have had the track record that I had, that ultimately my appeal lawyer was able to present to the sentencing judge who I had at that time. Now, as I mentioned, it was 4 years since the time I was convicted to the time I had served and been back down to court. And that original sentencing judge had retired. So I had a second judge who surprisingly was a judge. He was fair and impartial. He said, you know, my lawyer said, look, this individual has been incarcerated 4 years. And if this individual was in free society for 4 years, you would have had to take into consideration all of the things that he was able to do in those 4 years. And I'm asking you to do the same. And the judge said, you know what, you're right. I actually will do that. And my lawyer worked diligently to pull together a 100+ page report and submitted it to the court. And it was through the prompting of the judge that actually I was able to get a lesser sentence. The district attorney, unfortunately, didn't want to budge on what the plea deal was going to be. And so ultimately, Abe was able to get a 8-year prison sentence with 2.5 years of post-release supervision. But that's also because the judge at the time had taken into consideration all of the things that I had done during that first 4 years of my incarceration.
So to some extent, at least, the judge in your case on the resentencing acted as a safety valve to use at least a persuasive authority on the DA to give you a lesser sentence, taking into account that all that you had done. But as I mentioned, it's rare that you don't have to waive your right to appeal in order to get the benefit of it. So I'd like to turn to Jared now, and I've got a series of questions for you about how things operate in New York. But first of all, what's your experience with appeal waivers? Do you see them?
We do, and they're incredibly common. And almost every judge requires them. Not every judge, but it's pretty frequent that judges will require them before someone can take any type of plea. So the plea process in and of itself is incredibly coercive, as people saw through the movie. But when you add that extra layer of going through this coercive process and not really having any way to address it, it really just removes, really any validity I'd say, to the legal system, to the criminal legal system.
And is, in your experience, is the trial penalty limited to just felony cases, or do you see it in other kinds of cases as well, like misdemeanors?
Not at all. Misdemeanors, violations, all of it. I think the thing that people need to remember is that the people that are being processed through court, the people that are being put through this really horrific experience, are people. And so whether it happens with a violation case or a misdemeanor or a felony, it might happen at a different time. You might have more discovery depending on what type of case it is, but the trial penalty is very real for really every human that interacts with the criminal legal system.
Well, and it's interesting that you talk about how pervasive it is with all kinds of cases. One of the reforms that came through in the last year or so, which I'm very proud to say NYUJ supported, was some discovery reform. But I know that for a long time in New York, people were actually offered pleas at arraignment or very early on in the case, and basically told that if they didn't take it, the offer would go up. Is that still something that you're seeing?
So I don't practice anymore, but I do know that at least in some boroughs, that still is an issue.
Yeah, well, that to me seems like one of the most, particularly for people who are of limited means, who may have jobs and families that are that depend on them. And the idea that you should have to give up your rights in order to get home or not have to come back to court repeatedly seems to me to be fundamentally unfair and flawed. Is that your take on it as well?
It is. And again, just bringing everyone back to the fact that the people that are going through this are real people. Going to court in and of itself can be really an incredibly traumatic experience. Oftentimes, you're the most hated person in the courtroom. So often, our clients are possibly the only Black or brown people in the courtroom. It can be just an incredibly dehumanizing experience. And to have, speaking as a defense attorney, to try to have a full conversation with someone about, what everything means, to talk to them about what are the potential immigration consequences, giving them the Sophie's choice of, if you take this plea, you might not lose your job, but that everything is up in the air. The fact that people could be parents and there could be consequences as far as the child welfare system goes. The criminal legal system is more than just putting people in cages. That's obviously a very big part of it, but it's a lot more than that. And there are a lot of different consequences that could ultimately result from any case, from a violation all the way up to a felony. And so to try to ask someone to process process the real penalties that could come from taking a plea or from just being there in the first place, without really giving them any discovery, it's incredibly coercive, and it really just leads to a lot of people ultimately waiving a right that's incredibly precious.
Now, I know that you and the Legal Aid Society represent people in all different kinds of situations, including juveniles. Now, we haven't looked at this in the juvenile context, but is there something about that we ought to know about? Absolutely.
I think juveniles in two different ways. One, for kids for people under 19 that are involved in the criminal legal system, being able to get a youthful offender adjudication could be life-changing as far as really limiting the impact of collateral consequences on them for really the rest of their lives. Sometimes judges will use, or prosecutors will use, the potentiality of a YO adjudication to coerce a plea from people, which is above everything else. It's incredibly coercive. It's unfair, and quite frankly, to threaten to take away a child's future if they don't plea is just one of the most pernicious things that really happens in criminal court. But it's a problem in juvenile court too, and people think that a juvenile delinquency proceeding, because it happens in family court, because it's not a criminal disposition, but it's a juvenile adjudication, people think that it's not as dire, but there are real consequences that can occur from even having that juvenile delinquency adjudication. If you want to join the military, if you want to be a police officer, even if you want to be an attorney, to try to change the system later, those can have real consequences. And there is certainly a lot of coercion that happens there as well.
And are the judges involved in that as well?
Yeah, the thing with state court, whether it's criminal court, whether it's Supreme Court, or even family court, is that judges are very involved in the plea process, much more so than they are at the federal level.
And have you had experience as I had when I was practicing, where judges, after somebody went to trial, even where they had discretion, they would go on the high end because somebody had turned down a plea offer?
Absolutely, and it's. I think, with everything that we're talking about now, it's just, there's just this idea that every single person that goes to court is guilty of what police officers are accusing them of being guilty of. So many of those judges, it's almost as if they're annoyed that someone is trying to exercise their constitutionally ordained rights to an actual trial. So really, like, that's just so much of the philosophy around why the trial penalty is really enacted, and you see it at all levels. It's just incredibly pernicious, and it's really disgusting. And
we're certainly getting to the nub of some of these problems, and I'm gonna move on to Robert in just a moment. But I do want to mention to everyone who's watching that you can send questions in. We're going to get to them in a little while. We definitely want to hear from you and get you and get your thoughts in and get you involved in the conversation. Robert, as I lead this up to asking you a few questions, I want to just let everybody know that I got to know about Robert's situation because NACDL and FAM have a state clemency project that we're doing here in New York, and he was one of the clients who was represented through that project. Now, he did not get clemency. The governor hasn't been giving too many of those out, although we did see we saw 3 of them, one of them from our project a week or so ago. But he did get paroled. Robert was recently paroled. And so, first of all, welcome home, Robert. And I want to begin by asking you what you were serving time for.
I was serving time for a murder in the 2nd degree and from a case in Queens County.
And why don't you just tell everybody the circumstances that led to you being arrested, charged?
I was arrested as a result of causing the death of a person that assaulted my mother earlier in the day. He had assaulted her, caused her some serious physical injuries, and I wasn't at home at the time. But when I returned home, I found this person at the house on the stoop with a gun, and I was able to take the gun from him. And when I believed he was going to attack me again, I fired the weapon several times, causing his death.
And what did you do the next day?
The next day I went to the local precinct. I turned myself in, gave a statement as to what happened. And from that point, I got arrested, obviously, and went through arraignment, the normal process here in New York. And I was about a month later released to bail, and I remained on bail for about 3 years.
So hang on for 1 second. So they actually allowed you to be released on a bail that you and your family were able to afford, even though you were facing a homicide charge.
Yes, some of the local politicians in the community and neighbors wrote letters to the judge. Some of the people from the school that I was attending at the time wrote letters to the judge as well and the DA. And as a result of that, the judge at the time let me go on bail. And I had an uncle that was able to help me get bailed out, and he did so, and I was released.
And by the way, what was your criminal history before that incident?
This was my first contact with law enforcement.
And so how long did you wait till you got to go to trial?
I believe it was about 3 years from, I got arrested in July of 1992, and the sentenced in June of 1995.
And in those 3 years, did you get arrested for anything else?
No, I had no other contact with the law enforcement.
So this was basically the only time you've ever had contact with law enforcement was when you confronted this individual armed who had injured your mother. You obviously went to trial, but before you went to trial, what if any offers did they make to you?
Initially, I was before a very punitive judge in Queens that a lot of people are afraid of. Was named Leahy, and he initially offered 5 to 15 years. That was the original plea offer. And then once the trial began and the testimony from the DA was completed, they had a conference with the judge and defense lawyer at the time, and then the plea went from 5 to 15 to 3 to 9 years.
And so you were facing a possibility of having to go to prison for 3 to 9 years. You had no history, no criminal history at all. I don't want to put words in your mouth, but I assume you felt that you had a good case for self-defense based on the fear and the circumstances that you were in when it happened. Is that about right?
Well, based upon most of the stuff from like the other lawyers that were at the courthouse when we went for appearances, most of them told me that Judge Leahy was a very strict judge, very hard judge. And if he allowed me to be out and gave me a chance to get myself together, I had a good chance at being found not guilty. And so that was based upon some of the lawyers that were in the well of the court from day to day, as well as my trial attorney. So that's the process.
I guess it's obviously based on what we said at the beginning, you were convicted. And what were you sentenced to after the trial?
After the trial, I was sentenced to 25 years to life. So I was given a life term after going to trial in the jury.
And do you know what the mandatory minimum would have been?
At that time, the mandatory minimum would have been 15 years to life, and I received 25 years to life.
So not only did you not get the minimum, but the judge went and gave you the maximum actually that he could give you at that time.
Yes, well, I had switched. Judge Leahy was no longer there. I was before Judge Corrado in Queens, and she gave me, I guess it was 8 times more than the plea that she offered a few weeks before. So it was kind of harsh.
Well, it's harsh is not the word for it. Shocking, revolting, distressing. Before I move on, I'm going to ask Susan some questions as a follow-up to what happened to you. I'd like everybody to know what work you've done since. By the way, how long did you serve of that sentence?
I served 24 and a half years. I was released this past October as a result of, they have a program in prison where if you do certain programs, you can get 6 months earned off your sentence. And I was the benefit of the 6 months. I got the 6 months off, and I was released 6 months earlier over the time.
And what work have you done since?
Since I've gotten out, I've worked with a nonprofit here in New York City called Worth Rises, and I did research on the prison industrial complex report that they put out every year. And we research a couple thousand companies and write about how they profit off of the criminal justice system. So it's a pretty lengthy report and pretty detailed. And I'm currently working with a city agency now, and that's very new. And it's a temporary job, a 1-year contract. So that's what I'm doing now.
Tell us what it is that you're doing.
I'm working with the COVID trace teams, helping trace the cases throughout the city and people that test positive for COVID-19. So I operate a computer pretty much, processing names and people's information in to help people trace them and find out their contacts and so on.
Well, it's pretty important work, and we thank you for doing that, and thank you for sharing your story. So Susan, let's consider Robert's case. I think of the Eric Wyant case in the film, the 20-year mandatory minimum, the judge's hands were tied. Still horrible that, a 3-year a sentence of 3 years turns into 20. In this case, the judge actually piled on way more than was required in Roberts' case. And I guess I want to start with you by asking this. If a prosecutor felt that 3 to 9 years, and a judge felt that 3 to 9 years was adequate for punishment, for deterrence, for protection of the public, what is the moral or ethical justification for a sentence that's more than 8 times greater?
There is no moral or ethical justification in my view. And unfortunately, Robert's story is not uncommon. We know from the people in the film, as well as the human beings here before us, that the trial penalty is so enormous that the more common experience for defense lawyers within the last 10 or 15 years is working with people who do everything that they can to avoid the trial penalty. And that is everything that's been talked about already, from waiving rights, waiving appeals, pleading to get out sooner, or pleading to get the case over with so that you don't have to return to court literally dozens of times to defend yourself and avail yourself of your Sixth Amendment right. Unfortunately, I've yet to hear any justification. I don't see that there is any moral justification for 8 times the penalty, 3 times the penalty. I have experience in a case that I'm familiar with where there's 15 times the sentence. 15 times, because the person went to jail. And this is a man that was required to register and was prohibited from registering his address at the local sheriff's station. But he was on 24-hour GPS ankle bracelet tracing, reported regularly to his parole officer, and everyone knew where he lived. The crime was failing to go to the sheriff's station to register his address. He had every reason to plead that everybody knew where he was 24/7 because he was being tracked. And the penalty for that was 1 to 3 years, and that's what he was offered. And he said, I want to go to trial. I believe that everyone knew where I was. And he went to trial, and the judge gave him, after the prosecutor ratcheted up the penalty, 15 to life. 15 to life, from 1 to 3 years as the plea offer. So I don't know what the moral justification could possibly be for something like that. Other cases that I'm familiar with also, the clients that I've worked with who are trying to maintain their anonymity now and get back into the workforce, get back into life, they absolutely forfeited a viable, defendable case because they were looking at mandatory time behind bars. Mandatory time, 5 years. A man with no priors. His case was an accident. He was completely overcharged. He was charged as if he had shot someone or stabbed someone. He'd actually scalded somebody in a restaurant with hot food. The man supported 2 generations, his parents and his 3 generations, himself, his wife, his children, and his parents. But rather than risk going to trial, rather than making motions to suppress, he was offered probation and he grabbed it. Well, who wouldn't? It's a viable, triable case from a defense lawyer standpoint. And heartbreaking to know that it's possible that he would have been vindicated after trial. But lose your job, having 3 generations lose their economic support, and go behind bars for 5 years when the judge had no option if he was convicted. That's an overcharging by the prosecutor, and that's people doing anything they can to avoid a nightmare of the trial penalty.
So let me ask you this from a systemic standpoint. When we look at how the trial penalty works in practice, and we've heard all of the panelists have talked about the various rights that you have to give up. What is the impact of that in general on our system when people fearing the kind of outcome that somebody like Robert experienced? What price are we paying for that as a society?
Well, we see it in the streets in recent weeks. People are recognizing that how insidious and how systematic all of this damage is. It's not just if you serve an inordinate amount of time in prison, but people are required to waive their right to challenge evidence, to challenge police misconduct. The reason why we have suppression hearings to keep bad evidence out or to keep evidence out, pre-trial hearings, is to vindicate people's Fourth Amendment rights sometimes, or the Fifth Amendment right to remain silent. When people don't understand that they can remain silent and they speak and they shouldn't have been told, or somebody was searched illegally. There are bad actors, and we all know it, and we've seen it in the demonstrations of late. There are bad actors in law enforcement, and the penalty for a bad actor is you exclude the evidence at a pretrial hearing if you found that there's illegal police misconduct, if you find that there's lying, if you find that there was no probable cause for the arrest, or there was no probable cause for the search. But if someone to avoid 15 times or 8 times or 5 times the penalty gives up and waives the right or is forced to waive those rights to avoid that nightmare incarceration, we never have them. We never vet those law enforcement officers in court and challenge their view. And that is a very, very dangerous reality that is systemic. We see fewer and fewer cases, not only brought to trial, but also challenged pre-trial. And it should be, because there's the opportunity to ferret out bad acts. And it also keeps law enforcement honest. If they're tested under oath through the system, by trial or by hearing, that's how you ferret out bad actors and you keep people honest. If they know there is no chance in hell that there's going to be a trial or a hearing, then there's not a lot of incentive to keep it clean and to tell the truth. On the contrary, there's a perverse incentive. And that also exists, unfortunately, with the prosecutors. There's a perverse incentive and people bring cases that should never be brought, prosecute cases that are too weak. So objects will be challenged in court are so remote now, given the penalties.
So in essence, there's a sort of it creates an incentive for prosecutors to threaten great enhancements in order to get rid of cases which they know have flaws in them by inducing people through this coercive factor to take pleas. Is that what's operating? And I'll direct that to you, Susan, or to Jared.
Yeah, there's no question that is what that occurs. That occurs on a daily basis. It occurs in New York in the state system, and it occurs in the federal system as well.
Well, I want to at this point transition to another discussion, and that's we're seeing the problem through Robert, through Eric's case, through Chris Young's case. We're seeing the problem of people who legitimately feel they have a case and they want to avail themselves of a fundamental right, and they take advantage of it. But there's a flip side when you have so much coercion, and people should be able to have a jury of their peers without being receive geometrically enhanced punishment simply for taking advantage of that right. Jessica, I'm going to be asking you to play this film in a minute, but I want to say a few things to Jessica's our tech person who's helping behind the scenes, because I can't tee up things like film clips on these calls. But I'm concerned about the prospect of so much coercion being in the system that people who are actually innocent plead guilty. And we're going to play a clip of an interview with a fellow by the name of Rodney Roberts, who pled guilty to a crime that he did not commit, as was proved later on by his exoneration through DNA. And I want to thank the Innocence Project for making the film available. This is a clip that runs about 2.5 minutes, and I think it's well worth taking a look at. and then I'm going to come back to our panelists to comment on it. Sound check. We're not getting sound. Jessica, I'm going to ask you to cut. We don't have sound, and I'll just basically let me tell basically what the story was. Rodney was picked up for some minor offense, and while they had him, they decided that he might fit the description of someone who had committed a sex offense. There was an identification procedure. He was identified, and he absolutely was insistent that he did not commit this offense, that he was 100% innocent of it. And Jessica tells me she's got it. So why don't we go back and let him tell his own story? I think it'll be a lot more effective than you hearing it from me. So let's give it another shot.
My fingerprints and everything, thinking that I was just going to be in, be out, or this is not, you know, maybe a simple assault and I'm gone. So they held me maybe 3-4 days more, and I'm like, wow, why am I still here? And they were saying, well, you're being transferred to Essex County, to the county jail. I'm like, for this? And something was wrong from the beginning, and they had already seemed to have sized me up already. And I met the attorney that was assigned to the case. He was a public defender. I said, what's going on? He said, well, you're being charged with a kidnapping, a sexual assault. Now, at that point, I went ballistic. I was like, no, you got the wrong person. I'm here for this. I don't know what's going on. You got the wrong guy. When I finally got to the court, this attorney, he came in and told me that the prosecutor office had a plea agreement for me. I'm like, plea agreement? I didn't even do it. You know, I pled not guilty. I'm innocent. He was just pressure. And he was like, if you don't take this deal, they only offer you 2 years. You'll be home in 2 years. And if not, you know, they're going to take it off the trial and the judge is ready to give you life sentence if you get found guilty. And I think you're going to get found guilty. And this is my attorney telling me, this is the one person I had to was there to help me. I felt like I was by myself. So I thought that to get home to my son, then my family, and to salvage my life, that the best thing I could do for myself was to plead guilty and fight it once I got home, or and at least I would be home in 2 years and I can fight it from there. When they said they found it, when the attorney told me, I knew that I was gonna win. I knew I was coming home at some point. That was it. I knew I didn't do it. I just needed the proof to show. Innocent people plead guilty not out of ignorance, but out of fear. I mean, you are afraid that you're gonna lose the one thing you want is your life. But that's it. You feel like I cannot handle this lifetime or during this time for this crime I commit. And if it wasn't for the DNA evidence, thank God, I'll most likely still be sitting in jail. If I didn't have that, if it was just because eyewitness testimony wasn't enough. So if I didn't have that, I would still be sitting in prison, trying to fight for my innocence and my release and prove that.
So thank you for queuing that up. And before I turn to you, Jared, for a series of questions about this, I also want to, I mentioned the federal sentencing reporter articles. There's one article in there by a gentleman by the name of Chris Ochoa, it's a firsthand account. Chris similarly pled guilty to a rape and murder, which he did not commit because he was being threatened with the death penalty. And his lawyer, his family even, everybody wanted him to save his life, and they were afraid of what would happen to him if he didn't capitulate. But we're talking about a system that now we have undeniable empirical proof. I think every lawyer has known this. Our panelists have all talked about this, that innocent people plead guilty. So I guess, Jared, my question to you is, what is it in the system that makes it possible for us to extract guilty pleas from innocent people? How do we allow that to happen, and what can we possibly do to fix it?
I mean, the system in and of itself is just inherently sick, and it's inherently broken. So much of the underpinning of what the current criminal legal system is a continuation of slavery. And almost every single person that I've ever represented in court, they can just feel how it's just palpable how their humanity is really stripped from them simply by virtue of just going into the courtroom in and of itself. It's very easy to sentence someone to a cage for a long period of time if you don't think that they're human in the first place. So again, so many judges, so many prosecutors just assume that any person that's being brought into the courtroom is guilty. So, if that person is asking for a trial, then they're just wasting the court's time. They're not taking responsibility for what they did. They are somehow morally bankrupt simply by asking for that Sixth Amendment right. So how do we fix it? I think that we really just have to, something that Khalil said earlier is we have to think about how we invest in communities, and the fact that you shouldn't have had to have gone through the criminal legal system in order to get access to so many of the programs that you got. I think that we need to really reimagine policing. One of the worst victim and incarceration. One of the worst victim impact statements that I've ever read as an attorney this was a juvenile case where my client was 15, two girls in high school got into a fight over a boy. My client busted the other girl's lip. It was an assault 3, which is an A misdemeanor in New York. It was a school fight, and that was it. And in the victim impact statement, I just remember the complainant saying, I can't believe that client's name is probably only going to get probation for this, or if she doesn't get probation, she's only going to spend, probably less than a few months in jail. And and luckily that didn't happen. But it's just, people don't realize a day in jail is a really long time. A year of probation is a really long time. I've had people plead and take jail time so they don't have to do probation. I just think that we need to really reimagine that depriving someone of their freedom is really extreme. And then just really reimagine the entire criminal legal system from that, and try to find different alternatives to, just incarcerating people and losing that people potential, and, really depriving someone of their humanity. There's just better things that we can do.
And I want to stay with you, Jared. I've got a question from one of the viewers, but before I get to that question, somebody's asked about the ability to view the film. So the film is not in general release yet. It will be in a few weeks, but if you contact either NACDL or FAM or NYUJ, we will send you a link so that you will have it as soon as it becomes available. So the question that I wanted to follow up with you on, Jared, from one of the viewers is, well, why don't we just have a law that says that people can't waive their rights? Wouldn't that solve this?
I mean, first off, how do you enforce that? But would that solve this? Probably not. Again, the criminal legal system is just so inherently coercive. And we're talking theoretically about all the coercive factors that are there, But like, you just have to remember that the people that are going through this are also just really traumatized from the fact that they might have been in jail for a few days, from the fact that, you know, they're going through a really racist court system. So, you know, would that help? Possibly, but I don't think that would. I don't think we can just snap our fingers like that.
You know, my view has always been that you can't fix the system piecemeal. You have to fix a lot of things together in order to reinfuse some justice and restore these rights. If you simply said no one can plead guilty, for example, you might wind up with a lot more people doing a lot more time. And you know, so you have to look at both sides of the equation. But I want to stay one more minute on coercion, and I want to turn to Khalil because I know that you've been working with this, you know, the community of people that have been affected by our criminal legal system for so long. And I want you to comment on a ritual that happens in every court, virtually in every court in the country, every single day. And that is when somebody pleads guilty to a crime as part of a plea arrangement, they are generally required to do what they call an elocution. They have to basically say that no one has threatened them or coerced them into pleading guilty. And if they say, if they don't agree that no one has threatened them, they say, yeah, I have been threatened or coerced, then the court will not allow them to plead guilty. But it seems to me that when somebody is saying, going through that rote recitation that they have not been threatened or coerced, but they're actually in a situation where they're being told you're going to get 15 to life or 20 to life if you don't take this, that is the biggest lie that's ever been told. Am I wrong?
Yeah, or the death penalty, right? I mean,
right.
Yeah, the consequences they run the gamut. I mean, look, the reality is that, as Jared said, the coercion is deeply built into the entire criminal justice process from the time of police interaction all the way up to conviction and even afterwards. But also hypocrisy is built into it deeply as well. I mean, and that's just one factor of it. The fact that you could say on the record that no one has coerced you or threatened you in any way, although most of the coercion and threats have been in the courtroom, the reality is that that just highlights one of the underpinnings of the criminal legal system, which is that hypocrisy is deeply baked into the result that we have.
And we're all somewhat complicit in this, although it's a unique challenge for the defense attorney whose ultimate concern is for the welfare of their client. And I can't help but think that, you know, we're being put in an almost untenable position when you believe in your client, you believe the client has a credible, reasonable story to tell, and yet you have to tell them that the consequences of taking advantage of the right to tell that story, to fight their case, could be so dramatic. So I have another series of questions that I want to bring back to Susan, but I want to go to Robert for one more minute. And I just, you know, based on your experience and obviously listening to this discussion, but having lived a quarter of a century in a prison, most of which was because you took advantage of a constitutional right. Imagine somebody who was in a situation similar to the one that you found yourself in. No history, a tragic event. No one can know for sure what was going on in a split second in a human mind in that situation. What would you advise someone if somebody asked you, what would you say to somebody with the benefit of hindsight, based with the choice that you had and the outcome that you experienced?
It's a difficult choice, you know, when you have this belief in your heart that you are innocent or that you shouldn't be punished for what you've done or just take responsibility. It's kind of hard to tell a person, you know, to plead guilty, but then knowing what I know, the amount of punishment you could receive, you almost want to tell a guy, hey, listen, you better take a plea, because if you don't, the system is really rough. They will put you away for a long time and your life will be taken away from you. You know, looking back, part of me says, hey, if I would have took a plea, I would have been gone years and years ago and could have moved on with my life. It's almost like Khalil mentioned earlier. I wouldn't have to sit in prison and take advantage of the programs there. I could have taken advantage of the programs in the community, you know. Yes, I attended college while in. Yes, I participated in TED Talks while I was in. Those are things I could have did in the community as well. But, you know, it just didn't happen. And I would tell people, hey, you got to really think long and hard before you say no to a plea now, because the system just won't allow you to get a fair chance, it appears to me now.
And I would thank you so much for being so candid and so eloquent. And I would just, the prerogative of the moderator, I would say that a system that puts people in that position is a system that needs to be done away with, because that's not justice. That's not anything close to what was contemplated when these rights were created. But I want to now turn back to Susan. I want you to talk a little bit about the work that the New York State Task Force has taken on, and hear about what you're doing, how you're going about it. And I know that the work is still a work in progress, but what potential solutions there might be.
Yes, well, it is still a work in progress, but the New York State Association of Criminal Defense Lawyers is taking a look by trying to garner the input and the experience of people that practice in the system to the broadest extent that we can. We have surveyed defense lawyers throughout the state. We've attempted to survey all of the prosecutors throughout the state in every county, and other stakeholders as well, to find what their experience is with the trial penalty in their professional lives. We're finding, and to try to present coherent patterns and a report, much like the trial penalty report that the National Association did. What's happening in the courtrooms across the state, and what are the causes of it? And what we're looking at fundamentally is how can we reform the system without tossing it entirely out, as you just suggested. And some of the things we're seeing is that having a judge involved in a plea negotiations isn't always helpful. It can be as coercive as not having a judge involved. There are concepts of that where judges have to move dockets and move cases, and there's pressure within the system in that regard, and that also strips people of some of the humanity on an individual basis. So through interviews, through telling stories, much like the film that we just watched, and through gathering statistics about what's occurring in the courts, we hope to present some reforms. For example, legislating a cap on how much higher a person can be sentenced, how much longer a person can be sentenced in comparison in relation to the plea offer they had before trial. Putting some kind of a cap on that, having legislation where you take a second look at an individual like Robert, that after they've been in for a while, and wait a minute, what are we doing here? Do we really need this person to spend another 20 years in jail when they've taken these courses, rehabilitated themselves, demonstrated that they are completely rehabilitated and ready to move back into society? Those kinds of reforms is what the task force is looking at, and also educating the public about how important it is that they know about this penalty, that they know how few trials there are, and that participating in criminal trials as a juror is as important an exercise of democracy as voting at the polls. Ultimately, society and our citizens have to hold our criminal justice system accountable by partaking in it and participating. And of course, there are barriers to that. Who's in our jury pool? Who can afford to sit on jury pools? Because a person of color sitting next to me that I defend is looking at a 12-person all-white jury from a neighborhood they have never been to or heard of. These kinds of systemic racism within the system, of course, is a reality, but citizen participation in it, and more active participation and enlightenment is the cure.
Well, thank you for that. That's a very comprehensive answer. I mean, to me, it seems like, one of the key problems that absolutely has to be addressed is the unilateral control over the charging process and then the overlay of mandatory minimums. I think that we are going to have to tackle that as a society. The second look idea is a great way to get, to release some of that abuse without doing away with mandatory minimums. But it seems to me that it's the interplay between the charging function and the manipulation of those mandatory minimums. Now, of course, when you have a judge who gratuitously adds yet another 10 years onto something just because they can, that's a serious problem. But I'd be curious if anybody wants to unmute and offer any other thoughts that they have as to how we can try to deal with some of these problems. Jared, Khalil, any final thoughts? Robert, I welcome it from you as well, and Susan.
Yeah, Norm, I'll take a swing. First, just let me say that it is a pleasure and an honor to be on this panel with everyone, but I wanted to say specifically to Robert, welcome home, and congrats on all of the work that you're doing with Work Rises and in the city. And Robert just very nonchalantly said, yeah, I'm it's a city contract, it's just 1 year. It's tracing of COVID, which in the midst of a pandemic is probably one of the most important civil service jobs that anyone can take. And although to you, it may just be typing names into a computer, the reality is that you're helping us overcome a very deadly disease. So thank you for that. What I wanted to say is we all too often think about how to rectify or change the criminal justice system, the one that we're referencing tonight on this panel, but all too often with the lens of the current criminal justice system that we have. And what we really have to do is completely remove that lens and think about how to really embrace some of the other systems that exist that are really truly focused on justice and fairness. I mean, the reality is, surprise, surprise, there are other ideologies that exist in terms of accountability, in terms of punishment, in terms of justice, that have existed for centuries before we've created our current criminal justice system. What we're lacking is the political will, and just the reality is the lack of education for the average Joe and Jane person, who, when they hear of the criminal justice system, they have all these preconceived notions that are completely false. So what I'm saying is that we have to, one, talk about how do we reimagine a system that has nothing to do with the current lens of the system that we currently have. Two, is that although in the context of what was said tonight, I totally understand all of the panelists saying that the system is broken and that we need to fix it. The reality is that the system is built the way that it's built, and it is operating the exact way that it was intended. And we can look at that statement across race, across gender, but the reality is that people of color, for as long as we've had the current criminal justice system that we have been overly punished, have been the ones who have been dragged into the system, and all too often are the ones that get who bear the most brunt of its brutality, of its inhumanity, and of its straight up and down just deception. And so we really do need to think about how do we have this conversation about a system that operates completely different than the one that we currently have. And I'll give you one solid example. When we talk about who the system is operating on behalf, all too often people will say, or the average Joe and Jane will say, well, it's the victim who this system is operating on behalf of, and then secondary, it's on behalf of the people of New York or people of whatever. But the reality is that if a quote unquote victim, if someone who has received harm, we've heard numerous cases where they're actually the last person that's consulted on what they actually feel true justice is. They're the last person that has any say-so in the matter, even if they say, you know what, I don't believe that person needs to be in prison for 25 years. I don't believe that person needs to go to prison at all. As a matter of fact, I don't believe that person needs any punitive nature. They probably just need some counseling, some form of help. The reality is that if we had a system now in place that strictly used the want of the person who've received the harm as the North Star, as the starting point, and everything else trickled after that, the reality is that we can't even imagine what that system would look like. And the reality is that the current system we have, as Susan mentioned, the perverse incentives that are currently built into the system that we have won't even allow for that. Because the reality is the more convictions that prosecutors have is the more successful that they're viewed. And so again, we just really need to reimagine a system that is quite different than the one that we have, but also using other alternative processes that exist, that again have existed for centuries, that do deliver accountability, punishment, and justice.
Well, I couldn't say it any better than that or any more comprehensively. I mean, I can't help, when you talk about a completely different system, Khalil, and I think about how this one operates, I'll bet you any amount of money that the jury that may have convicted Robert had no clue as to what the punishment was going to be. The public, you're absolutely correct. The public has a grave misconception about how severe the system is. Many people in the public don't realize that. Many people in the public do realize it because they've been victimized by it. And one of the things that I've learned of doing clemency work over these last several years is one cannot imagine how much of the draconian sentences comes from people being over-policed in certain communities. These enhancements, these predicate felony, these persistent felony things, they always fall on the least, on the people who have the least means and are in the poorest circumstances, because that's where the policing resources are going. I open it up for one final comment from Robert, if he wants, or Jared, or Susan.
I would just like to say thank you for having me here and all the good work that you guys are doing. And I actually benefited from the work and the Clemency Project. They wrote a pretty good report for me that helped me with parole. And I'm thankful for the work that they've done. And over the years, I knew that I had to take advantage of the programs and opportunities that were available within the prison so I wouldn't become bitter. I know a lot of times when you serve a long sentence, you become bitter, you become angry at all of the things that you think should have happened in your life. And it was a good thing to have programs available that were positive. Unfortunately, most of the programs were not state-run programs. They were ran by volunteers and community members that came in. And I saw one of the comments tonight was from one of the volunteers that I worked with for many years doing the RTA program. And it's good to see people, that genuinely believed in my future, that took time out to come to prison and volunteer and help us along the way. And it's great to have people believe in your future and give you a second chance. And I just want to say thank you to all the volunteers that go into prisons around the state and help men and women and help them transform their lives. A lot of people don't know how many people volunteer to come in and subjected to harsh treatment by the guards when they get there, but they still come in week after week and help us out. And I just want to say thank you to all the volunteers, all the lawyers that I had over the years, and the people on this panel, because this is the type of work that will actually help change the system and make the public aware of what's going on within the system. Again, thank you all.
Thank you. Thank you. Jared, I think you're ready, queued up.
Yeah, and I'll be pretty brief because I think everyone has said it much better than I ever could. But something that I really do think that people need to be aware of and really to think about is just that the police are not infallible. I think, again, like the trial penalty is the way that it currently is because people assume that if a police officer is saying that this person is guilty, then it is okay to punish that person as much as possible. I became a public defender in 2014, the year that the NYPD killed Eric Garner. And 6 years later, despite video after video of seeing them brutalize Black and brown communities, their budget has gone from about $4.6 billion to just under $6 billion. Police have been the second or third most respected profession in this country for such a long time. Police can do just about whatever they want to communities, and between cop unions, between institutional police forces, they are able to fight back against almost any measure of accountability for them. So I think if we really do want to restructure what the criminal legal system looks like, and if we really do want to introduce some equity into what the trial process looks like, we have to, I think that starts with recognizing that police are not infallible. They often make mistakes, and they often don't make mistakes, but they just do like really pernicious things on purpose. Police are the people that took, you know, their freedom away from people here, from the Central Park Five. There's just so many different instances of police just making really horrific mistakes. And I think that if we remember that people's entry point into the criminal legal system is from this force that has, quite frankly, always been on the side of oppression from the inception of modern American policing, when they basically, you know, chased down runaway slaves, to attacking people with dogs and fire hoses when they were fighting for Black liberation, to its Pride Month, to the Stonewall Rebellion, to what we're seeing them do to protesters in the street now. The criminal legal system is inherently flawed because the way that people enter it is through policing. And until we change that, and until people are really recognizing that that is a problem, our people need to recognize that that is a problem for us to have the bigger structural changes that we really need.
Absolutely. And just like videotape allowed us to see that brutality in a way that people didn't in years past. So I believe if we could bring some sunlight and transparency into the whole criminal justice process, so that these things could be litigated from start to finish and expose some of this through the process, it would be, that's what these fundamental rights are all about. Last word to you, Susan.
I would just like to follow up a little bit on Robert's experience, and also from a criminal defense lawyer perspective. You touched on this a little bit, Norman, about how difficult it is as a defense lawyer who feels like the last line between liberty and mass incarceration, and sitting down sometimes and talking to somebody who's either by choice or by assignment put their life and their future in their hands is a daunting responsibility, and that most of us that take that responsibility on as a career choice take it quite seriously. And sitting down to tell somebody, yes, you have a viable, triable case, you might win, but if you lose, you may get 20 or 25 years, and you only live 20, is a very difficult conversation to have. And it takes its toll on everybody in the system. And sometimes that can really damage an attorney-client relationship when you want to be the person that guides someone that's in their darkest hour that's been accused of something, and you're faced with these daunting penalties, a judge maybe with their fingers in their ears, and a very inexperienced, most of the time, young person with enormous charging power and very little sense of what's valuable in life, and very little experience in life. And that, from a defense lawyer's perspective, can be overwhelming. On a more happy note, I would like to say that I am encouraged and thrilled and awed and humbled by people like Robert and some of the people that I represented on clemency petitions who were serving life sentences, life, with no hope of getting out, and got up every day and learned, read, studied, bettered themselves, and did more with their lives incarcerated than so many people do on the outside. That, to me, gives me hope in our society and in humankind, and I'm so grateful that there are people like Robert in the world, and that some of my clients that got clemency exist. And hats off to you for your perseverance and setting a role model for us to do more with what we have on the outside.
Well, I want to thank all of you. What a phenomenal panel. the passion, the desire to pursue justice, and the dedication that you bring to your work and to this issue is really humbling. You are all genuine heroes. And I hope that the viewers will come away from this and from the film, The Vanishing Trial, with a new sense of one of the tremendous problems that we need to fix, get rid of, start over, what have you. We'll do it. Like I said at the beginning, one of the things that well, there are a lot of reasons for some encouragement, even in dark times, and the massive protests, the new awareness, and the cross-ideological excitement behind trying to do something is a reason for some hope. So let's leave it on that note. Jessica, if you want to just put that slide up again, so anybody who wants to go to those links can find them. And again, we will be making publicly available the film in a few short weeks. So thank you all very much for participating, and have a great night.